Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law in San Antonio, Texas, in the U.S. And the reason I'm sharing that I'm in the U.S. is because today's guest, Phillip Young, who is the co-founder and CEO of Garfield AI, is joining us from the U.K. And welcome, Phillip.
Good evening, Patty. Thank you very much for the invitation.
Well, I read about what you were doing with Garfield AI, and I was so interested. I reached right out and asked if you would talk with us about it so we could hear more here in the US. And thank you. Thank you for saying yes. So let's start with learning a little bit more about you. You are a barrister in the UK, correct?
Not quite, no. I'm the other side of our split legal profession. I'm a solicitor, and just to confuse people, we have a sort of form of solicitor that also has advocacy rights, higher advocacy rights, called a solicitor advocate. And I'm one of those as well. So I'm a sort of strange fusion in that I both act as a solicitor, and when I was in practice, I could also do advocacy like a barrister. But in practice, I tended to act as a solicitor in a law firm because advocacy is very much an art, not a science. And I wasn't going to be doing enough of it to make it worthwhile me doing advocacy all the time rather than everything else that needs to be done in a litigation case.
So what kind of work did you do when you were a solicitor?
My practice was in the City of London, and I specialised in complex commercial litigation and arbitration, normally big ticket stuff, normally transnational. So there was often conflicts of laws and parallel litigation operating in multiple states, including many cases I fought where there was litigation going on in America in parallel within England. And in fact, on a few cases, and one of them is an important reported case in England, parallel litigation between the Texas State Court and the English High Court, which was all around non-exclusive jurisdiction clauses and the English court's power to grant anti-suit injunctions, which I think would be in Texas terms the equivalent of one of your TROs. So that was what I specialised in, and my career was spent, the early part of my career was spent at a firm you would have heard of called Baker & McKenzie.
Yes, of course.
Very fine American firm, founded in Chicago. And then for the last 13 years of my career, I was co-founding partner of my own firm with originally two other partners called Cook, Young and Keedon, which you would, I think, describe as a boutique specialist firm that just specialises in complex commercial dispute resolution. Very fine firm. I retired from 2 years ago, and we grew it over 13 years from 3 of us and Gerald's sister did all the real work, to about 50 of us. That's my background as a lawyer.
That is quite a growth for that firm. So that was your career as a lawyer, or at least traditional lawyering. And at some point you decided to do something different, and share a little bit about what that was and why you did it.
So another event that you would have come across, a little thing called COVID happened. And like a lot of lawyers, I'm relatively gregarious. I think relatively gregarious by English standards, not necessarily by American standards, because Americans tend to be more friendly than English people in most circumstances. I found sort of having to stare at too many people and trials over a screen rather wearing, and decided after that I wanted to travel the world. So I retired in the sense of English partnership law from the firm I co-founded, CYK, and I actually went traveling across America. I did a 3-month road trip from Boston to Seattle with my family, and that's actually the original genesis of Garfield, because while we were in America, this would be November 2022, ChatGPT 3.5 was released, and I had time on my hands, and I'm also a giant nerd as well as a lawyer, and so I played with this thing, and the more I played with it, the more I thought, crikey, this thing is going to be utterly transformational for law and legal practice and litigation. So I parked that thought because I was having too much fun going through your wonderful country and seeing all the scenery and meeting wonderful Americans, small town Americans, big city Americans, Midwest Americans on the top of the Rockies, you name it. And I was having too much fun doing that, so I parked that thought. But then I came back to it in April, May 2023 when ChatGPT 4 was released, and that was a big jump in capability. And so that's really when Garfield began.
So I have to ask, did you make it to Texas?
No, I've never made it. So I know quite a few Texan litigators, and they are forever saying, Philip, why have you not come to Texas? Texas, they tell me, is the center of the litigation universe in America. Now, I suspect some bias. Yes, I've never been, and I've always wanted to come, and we didn't get down that far, unfortunately, because we were going across the North Country, but one day.
Well, you have an open invitation. I thought you were going to say Texas is the center of the universe. I thought that might be the message that you got.
No, that's definitely Yorkshire. But I've been told that by a lot of people that live in Yorkshire, so that has to be true.
Before we move back to Garfield, did you and your family have a favorite place in your northern tour of the US?
Oh, goodness. So Anglophiles are people that really like England. And if there is a word for people that really like America and Americans, then I'm that person. An Americophile? Maybe someone else who's listening knows the correct word. But there are very few bits of America I don't like. Perhaps some of the really big cities. Obviously, places like New York are very interesting, but the middle of Detroit was not not my favorite place. But if I was going to pick particular places, I really like New England, and we were there in the autumn, in the fall, and that was just glorious.
Perfect time to be there. Yeah.
Oh, just glorious, absolutely glorious. I mean, what's said about the fall in New England is an understatement. I really like the Black Hills of South Dakota. That is a lovely, amazing place. And I really enjoyed going through Wyoming. In fact, while in Wyoming, we actually saw genuine cowboys herding actual cows, which I assumed all of that had sort of become merely a historical thing. But no, genuine people on horses, wearing leathers, with guns, herding cows. It was amazing.
That actually can be seen in Texas.
Oh, there you go. Yeah,
Yes, they are still doing that. But well, I just am so delighted that you got to do that. What a wonderful experience for you and your family, but one that we as Americans do not take advantage of on the whole. So I think more of us who live here and have all of this available to us should take advantage of. But how wonderful you did.
Yes, no, I agree. While we were driving across the country, from time to time, particularly as we got farther and farther away from Boston, people would come up to us who were going back the other way, and they'd say things like, gee, you've come a long way from Boston. And of course, then, because when you're in a foreign country, your accent becomes even more sort of stereotypical. I would say in my most British accent, rather far than you think, old chap.
All right. Well, because of this inspiration and you're playing around with ChatGPT, you came up with the idea for Garfield AI, but there was an impetus to that also personally. You want to share that?
Yes, absolutely. So I wanted to do something with this new technology because I had time in my hands and I wasn't in practice. And you need to have a problem to solve, a real problem. And the problem that had been irking me for years was the problem that my brother-in-law has. So he's a plumber. He's near a city in England called Sheffield. American people will know Sheffield if they know the actor Sean Bean or the musician Joe Cocker, because lots of sort of actors and musicians have come from there and gone global. It's a sort of, you can think of it as a sort of a post-industrial city in the middle of England. It was once renowned for its steel. And yes, Andy's problem was a problem that all small business people have because he's a plumber. And from time to time, people just don't pay him. And it's not a regular problem, but it happens enough to annoy him. And they're not paying him because they're insolvent, because that's just a risk of doing business. And they're not paying him because there's an issue with the service. They're paying him because they know small business people don't have the time to chase debts, to write lots of letters, to make phone calls, and then are intimidated by the court process. Even though we have a small claims process in England, it's supposed to be simplified, you're not supposed to need lawyers for, it's still daunting. And using lawyers is uneconomic. And that's no criticism of my profession. It's that it requires human time, or has done traditionally, and that is inevitably expensive. So whenever Andy had those problems, like a good brother-in-law, I'd step in and help him get paid, because for him, a couple of £1,000 is not much for a city law firm, but for him, it's a summer holiday. And so, yes, it might be thought to be overkill that Andy would then have a city litigation partner step in and get him paid, but what a brothers-in-law
for Andy.
yeah,
I'm
lucky
sure
for
he
Andy.
was
Yeah.
appreciative.
So what I wanted to do is I wanted to build something to help all the Andys of the world, something that would basically take a small debt claim from the beginning stage of triaging to see whether the claim is indeed a small debt claim, all the way through the court process, regardless of where the case might end up, because it could get paid, relatively early, pre-action, might get settled. It might be that you have to issue claim form, which is our terminology for a writ nowadays here in England, and then you just get ignored, so you have to apply for a default judgment. Or it might be that you even get a defence, in which case you need something that can take you through to the small claims court trial, which in England is a 1-hour trial. So I decided actually that was a problem that was worth trying to tackle, and that's what I decided to build. And I went out and I found my technical co-founder, a guy called Dan, who's a very clever guy. I'm going to say he has a background in quantum physics. And the reason I'm careful about that, because he has a master's and he was reading his PhD in photonics and quantum physics at the time this started. started, and he then dropped out of that to go all in on this, is because when the Financial Times of London found out about us and they described him as a quantum physicist, quite a lot of people then commented on the page to say he's not a real quantum physicist because he doesn't have a PhD. So I'm now, I think he was a little bit, his eyebrows went up at that. So I now say he has a background in quantum physics. But yes, between the two of us and the team we've built, the last 2 years we've been building Garfield, and we're now at a point, which we'll talk about in a moment, I imagine, where we're launched and we're regulated and we're operating.
So first I want to ask, why did you name it Garfield?
So this was an in-joke that sort of stuck. So when I was at Baker & McKenzie 25 years ago, I made a friend called Garfield Smith, who is another English solicitor. Nowadays, he's a partner in his own London practice, specialising in technology law, particularly specialising in early stage technology companies. And for years, he would say, Philip, you should have been a technology lawyer because I'm a big nerd. And I would have said back, of course, you should have been a litigator because everyone knows litigators are better than technology lawyers. And that joke has been going on for 25 years. And when I started this, I basically had to admit to Garfield that he was right. I'm now a technology lawyer, so he's won. So I said as a joke, I'm naming it after you because you've won. And we never expected it to stay with this name. We expected to come up with a real name, but after 2 years of lots and lots of people trying to think of a better name, we've not managed to think of a better name. So it's just stuck. So it's now Garfield, and I think he's flat. I hope he's flat.
I'm sure he is. What an amazing legacy to be a part of. So Garfield AI has become the first SRA-regulated legal AI in the UK, and the SRA is the Solicitors Regulation Authority. Can you describe that for us, what that means, the SRA, what its job is, and how it regulating Garfield AI has really set this on the course to help people with their small claims, as you've described?
So yes, in England, as I've mentioned, we have a split legal profession, which once upon a time, I understand America had, until the small disagreement in 1775 led to a sort of slight parting of the ways. But yes, we have barristers and we have solicitors, and once upon a time, solicitors were called attorneys over here, like they still are in America. And barristers conduct advocacy and solicitors do everything else. So solicitors do transactional work, and for contentious work, they interview witnesses, they liaise with the clients, they prepare court bundles, they deal with strategy, they deal with the other side's law firms, all of that sort of work. They just don't necessarily go to court and do the advocacy. That's what barristers are brought in to do. So you can think of barristers as being analogous to American trial lawyers, hired gun trial lawyers who are brought in to do the advocacy stage of a case. So the SRA is a regulatory body that regulates solicitors, and there's a separate regulatory body called the Bar Standards Board that regulates barristers. And in England, if you were going to conduct something called a reserved legal activity, that's a defined term in the Legal Services Act, you have to be authorised and regulated by one of those two bodies. And I knew at an early stage, because one of my sidelines in practice was I did some professional discipline and some professional negligence work. So I'm very, very familiar with the regulatory framework for lawyers in England. I knew at an early stage that what Garfield was doing was conducting litigation, which is a reserved legal activity. And therefore, in order for Garfield to be able to operate legally and for me not to go to prison, which I'm not keen on.
I'm sure nobody in your family was either.
Exactly, yes. Wouldn't be the highlight of my life. I had to be authorised and regulated, which meant I had to approach the SRA to achieve that. And you can think of it as wrapping Garfield within a law firm. So where we got to after an 8-month dialogue with the SRA was in March, we were authorised and regulated by the SRA. So we are a law firm, an English law firm, just like every other English law firm. We comply with all the same ethical standards and regulations and rules. But there's 4 things about us that make us unique. First, we provide our services solely through an AI product and not through humans. And as far as anyone knows, and I think the reason that the media has been so interested in this, that might be a world first, because we're not aware of any other law firm anywhere in the world that does that yet. Secondly, at least in England, we provide a litigation service through AI, which no one else is doing at the moment. Thirdly, this is a little bit less unusual, but we provide only one service, and that is small debt claims. Most English law firms are more full service or have multiple offerings, but we just do one thing. And that's a deliberate decision on our part. And fourthly, also for reasons of client confidentiality and avoiding conflicts of interest, we only do one side of small debt claims. We only do the claimant side. We could do the defendant side, but because we've got the technology to do so, but we are not going to do that. That's what makes us very unusual, and the reason why in the last few weeks my life has been turned upside down by the interest all over the world in this.
So it's pretty amazing amazing that you all have gotten the authorization from the Solicitors Regulation Authority. And I'm thinking that might be akin to our bar associations here or the rules of the state Supreme Courts, something along those lines. And so congratulations. That's huge. And the announcement has gone out and you said it's generated a lot of interest. So what kind of interest have you encountered?
So it seems that an awful lot of lawyers are very interested in this all over the world. And we have seen articles about this appearing in publications, not just in England and Wales, but the rest of the UK and in many other countries as well. On every continent, actually, where there is operational law firms, there seems to be writing about this, which is a surprise to me. I didn't think we were that interesting. We have received an awful lot of interest from the public sector as well as the private sector. So the government has been very interested here. And a few months ago, we were summoned before the Justice Select Committee in Parliament to show them Garfield. The senior judiciary in England have been very interested in this and very engaged. And I might talk a little bit about that separately in a moment. We've also been approached by foreign governments in the last few weeks and also various foreign judiciary, members of foreign judiciary. I think there is a general view around in the legal profession and also in governments and in the judiciary and in other stakeholders like in England, the Ministry of Justice, that AI is coming. It's going to affect every area of legal practice and law, and anything that's novel, obviously people are interested in because they're wondering whether it can be adapted for their jurisdiction. We've also received a huge number of inquiries from all over the world, from China, Peru, America, Australia, other countries in Europe, you name it, from people asking if they can license Garfield for their jurisdiction, which is very flattering, but may not fully appreciate the challenges involved in that.
Absolutely. That's probably down the road, but I can see that being a very difficult end stage. As far as all the interest, certainly from an access to justice standpoint, from a pro se litigant standpoint, from a judicial efficiency standpoint, all of those things would really make Garfield AI appeal to lots of different stakeholders. But I can imagine there are some who are not as delighted by the idea of AI law firm representation. Have you heard from any of those people, and is it generally an anti-competition criticism, or is everybody just thrilled with this?
I was expecting to be received very skeptically and rather negatively, actually, because the profession tends to be, in my experience, conservative with a small c, risk adverse, because that's how we're all trained and how we think as lawyers, and cautious. But actually, I've not seen much, if any, negative commentary on this. And I think partly that's because what we're trying to solve is an access to justice problem for the small guy, and everyone likes to help the underdog. Secondly, I think there's a realization that this is coming and it's going to happen, and therefore people were interested in when it is happening. And thirdly, I think that human curiosity is an amazing thing. People are just interested in something new. So we've not seen a lot of pushback. And so I was going to say something about our judiciary. So the last couple of years, there's a bit of a theme of things happening on holidays for me, and I don't want to give you the idea that that's where I have all my best thoughts. But last summer I was on holiday with my family, and whilst I was watching people in the pool having fun, it suddenly struck me that, of course, I should reach out to the senior judiciary in England to find out what their reaction would be, because if they wanted to kibosh it, then I should go off and do something more productive with my time. So I obviously know a number of the senior judiciary personally from my years of practice, and so I emailed and I said, this is very unusual, but could I come in and show you what I've been working on? And it's not my normal practice, it's an AI law tech thing. But they were, sure, yeah, bring it in, we'll have a look at it. And the reaction was far more positive than I thought it would be. And what the judiciary said in our country, and I suspect this might be echoed in other countries, is look, if you're a judge, you're all about access to justice. That's number one. Point number two, the biggest problem the judiciary have in England, and I imagine in other countries, it's difficult to get representation. And every judge's heart sinks when someone comes into court carrying a bag full of loose leaf papers, because litigants in person take up a vast amount of judicial time. And so anything that can give them a form of representation and ensure a uniformly good quality of case and presentation of case is going to save a lot of judicial time and is going to enable better decision making and disposals by the court. And they also said, and this is a fair point and not one I hadn't thought of before. They said, we're not worried about the floodgates, because they said in England we have well-known problems with the funding of crime and family, and to a lesser extent civil. And they said a large chunk of our existing funding comes from the bulk debt issuance that courts in Northampton do for us. And if you expand that, then because about 80 to 90% of all small debt claims never get near a judge because they are either paid or they result in default judgment, they said we would actually be making net revenue that we could use to fund some of the underfunded parts of the judicial system. So they said from their perspective, this sort of thing is great. And my impression from talking to judges in other countries, it's been common law countries so far that have reached out, judges from other common law, is that they all have exactly the same thought process. And they're also thinking debt claims today, but what is it going to be tomorrow? Is it going to be employment claims? Is it going to be little personal injury claims? Is it going to be sort of more stressful court experiences, like when somebody unfortunately has to get divorced? And there's a lot of people that don't get represented for that, And so I think the judges, a lot of gears are ticking, and they're thinking this could be incredibly helpful for both the court service, but also for people that use it.
So I'm delighted and not surprised that the judiciary is excited. And, some of your best ideas happen on holiday. I think that's a good lesson for all of us, right? We should take holidays and do some
Take your holidays, yeah. And travel across America while you're doing it. That's the other lesson.
That's right. And so I've done some reading about Garfield AI, and of course, people get concerned about AI and confidentiality and privilege and all of that. And you all have solved for that. And I won't ask you to kind of get into the technical components of that, but I'm just going to go with the assumption that you have taken care of those issues.
Rest assured, the SRA asked many questions, and one of their big areas of inquiry was quite rightly sort of compliance with the ethical rules and the regulatory framework. And they were right to do so. And of course, as a responsible solicitor, I've been thinking about that since day one.
Absolutely. I think that's one of the keys to your success, is because this was envisioned and created by a lawyer who understands what the
rules. That's a very interesting topic, and one I'm quite passionate about, actually. So I know a lot of tech guys, and they're all lovely, but some of them think they can build law tech products. And what I've been saying to all of them is, if you're going to build a law tech product, you have to have a lawyer who is a domain expert, who's got a lot of experience in it, who is the product manager, because every practicing lawyer knows that there is so much that is experience, practice, and is not written in any book. What a technical guy would call edge cases. And you need to have that built into the product from the beginning. Otherwise, the product just won't quite work.
So you've taken care of the confidentiality, the privilege issues. It's complying with the rules as if a lawyer were doing this work instead. Is there some sort of review function by a lawyer, or is it solely between the client and the AI to ensure that this is consistent with the claims and the rules and the court?
So to begin with, what I volunteered to the SRA, and they've agreed, is that I will check the documents going out the door. So there will be a solicitor double checking everything. But the intention is that as we become more and more established, and we've done more and more claims, and we've got a large data set, and we can prove the quality is where we want it to be, then I will move to, rather than checking every document, I'll move to a sampling approach, and I'll move to very much a risk-based sampling approach, because that's very much the way our regulatory scheme is set up in England. So, for example, a lot of small debt claims don't go anywhere near a judge. They're basically just a series of, what my quantum physicist co-founder, I just called him that then, he'll get more comments in the Financial Times now, what he likes to call a sequence of relatively closed problem spaces, which is a phrase I love, and I now go around quoting that. Those can be dealt with a very high degree of confidence in their reliability. And so eventually where my attention will be at the relatively, the small minority of cases that are actually defended, where the problem spaces are less relatively closed and more open. But you can also build, and this sometimes comes as a shock to lawyers who are not mathematically minded, you can build electronic tools essentially in software that can offer you mathematical confidence grades, to put it in my terminology rather than a mathematician's, of the quality of documents. And so you can therefore have a tiered approach to this, where you can run all documents in the first instance past that sort of assessment process, and only draw documents to a lawyer's attention where they are below if you say, I don't know, you want a 95% quality level or 98% or 99, you can take that sort of approach. And so that's probably where we'll end up eventually.
Okay. And so you're in the pilot stage now. And how extensive is that pilot? What numbers are we talking about now of users and experiences through Garfield AI have happened already in the courts?
So I'm afraid our court system is it tries to be quick, but it's not notorious for its speed. And to give you an idea, a county court case in England from beginning to end would normally take you, assuming you're having to fight one to trial, it's not just issuing a claim form or getting paid pre-action, would normally take you anywhere up to 8 months to a year. So we've been authorized for 2 months, and so we're still at the pre-action stage with live claims. Obviously, with our system, in order to build it and test it properly, it is essentially a synthetic county court system where we can test every single stage of a county court case, and we can run huge numbers of dummy cases through it to test. So we have tested it extensively with dummy claims, but on live claims, we're only up to the point where some people are beginning to think about issuing a claim form. Our user base has been a really interesting mix so far. So we have everyone from sole traders up to really big companies with a proper CFO and a finance function and credit controllers and the whole hoopla. We've got law firms, we've got accountancy firms, we've got other professionals, medical doctors, surveyors, you name it. Really, the whole gamut of businesses of sort of England and Wales is represented in our early adopters. And so far, I mean, we've had some very kind testimonials from people that have sent a letter out and then got paid. And in fact, we had the other week somebody who put on LinkedIn, so it's public, some very kind comments about us. He was a senior partner of another London law firm, and I didn't know him before this, but he's building a tech business, and he had some unpaid invoices from a mediation he'd done. So he decided to try Garfield out, and he was delighted that it just generated him some letters of action really quickly at very minimal cost. So he very kindly said some nice things about us. So far so good, but this is early days, of course.
That's really outstanding. So what is the economic model with Garfield AI? In the States, we would have lawyers who took a percentage of the recovery, that kind of thing. How does it work with Garfield?
So we've tried to, because we're all about access to justice, we've tried to make it as accessible economically as possible, even for small claims and small business sole traders, because we're trying to help the Andys of this world out as our priority. So what we've done is as follows. First of all, we don't do subscriptions because they're a barrier to entry. There are no lock-ins, so people can leave at any time. And so if anyone wants to go and use a traditional law firm or do it yourself, they're more than welcome. And we have adopted a pay-as-you-go system where therefore there's no fixed fees, there's no percentages of recovery. You only pay for the stages you use. So if all you have to do is send out a letter for action and you get paid, you're paying hardly anything. If you have to issue a claim form, you pay a bit more. If you have to actually fight all the way to a trial, you'll pay more again. But you're only paying for what you use. And we have, in England, unlike in America, we have this principle of cost shifting where the successful party often recovers their legal costs from the unsuccessful party. Now, in small claims, that is heavily mitigated, but you're still allowed to recover some costs from the defendant if you're the claimant. And our fees for those stages of the court process are at or below the court mandated fees, which means that if you use Garfield and you're the claimant and you prevail, and assuming the defendant, the debtor, is solvent, you get all those fees you paid Garfield back, which means in net terms, you'd be paying to Garfield hardly anything at the end of the day. So that's another attraction for creditors to use us. And it's also a disincentive for debtors to be recalcitrant unreasonably.
Well, I love that economic model that truly is providing access. And opposite what I think one might expect from a startup tech company that's turning the industry standard on its head, it sounds like this is not a play for some world domination in this commercial sector.
No, I don't think I'd be very good as Dr. Evil. No, I mean, I was a practicing lawyer for so many years and that wasn't a badly paid job, I can say. And so I wanted to do something different. And the way that we're structured, we don't have any VC or PE money behind us. There's no disrespect to those sectors. I know them very well. It's just that I thought for something like this, it's really important, particularly when you're seeking regulation from a regulator who'd never done anything like this before and would be, inevitably nervous about this, that you want to show that every part of what you're proposing is aligned with what the regulator would expect. And so not only is there some of my own money behind this, but we have some angel investors, and they're all professional people. They're all the sort of people that understand that the ethics and the overriding things that lawyers should be thinking about, i.e. the interests of justice, are more important than the economics. Obviously, we hope that this will be successful, in which case it will repay everyone. But it's not the sort of typical business model where people are desperate to scale rapidly at all costs at the expense of the quality of the product. And I think if we had been like that, the SRA would quite properly have rejected our application.
Absolutely. So what do you see on the horizon? Obviously you're still at, early stages with live clients, but I imagine looking across the voids in access to justice, you see some areas that Garfield AI might be interested in moving into. So what might be next?
Yeah, so there are obviously many different types of small claims in England that are comparatively badly served for legal representation. It has to be said that the debt market for small claims in England is enormous. Depending on which study you read, it's either 6 billion a year, anything up to 50 billion pounds a year. So that's a big market. I mean, England and Wales is obviously a big economy. So that will probably keep us busy for a bit. Then it becomes a question of what thing do we think we can solve next? And it could be, and this is speculation, we might decide small personal injury claims. We could decide, housing claims, housing disrepair claims. We could decide any number of things. I think what will be driven very much by is where there is demand, where people want something built. And we'll also need, I think, to look very much at what the statistical shape of the claims are. So debt claims were attractive, not just because of Andy's problem and obviously the addressable market was significant, but also because debt claims are the simplest form in relative terms of a commercial claim. The law is straightforward. These cases are largely fact. So other claims are not necessarily so straightforward. So personal injury claims, statistically, they're about 50% likely to be defended. So you'd have to think about where the technology is at that time and whether the technology is able to provide the same type of service. But it's still quite early days. So at the moment, I'm still busily beavering away, making sure that the small debt claims are where they need to be before turning my attention to other things.
What's the size of your team at Garfield AI?
So there's Dan and myself, and I do some programming too. And all of my team have been very gracious in my efforts, but I've got grey hair now, and I learned to program in the 1980s. And so the modern style of approach is, I think, somewhat better. So I've been having to adapt, and they've been very kind and not laughed at my efforts too much. But in addition to Dan and me, there is another 3 people in the team. So we've got 2 front-end developers, 2 back-end, and that's 5 of us altogether. We're about to go to 6 because we're looking for another back-end developer to join the team. In addition, there's about 15 of us altogether, because there's a wider group of people. So there's other solicitors and there's a barrister. We've got a very successful tech entrepreneur in the group who gives a lot of sort of guidance, all sorts of other sort of disciplines, a management consultant, some accountants. So it's really handy to have so many different disciplines and points of view. It means that the product gets an awful lot of love and attention.
Well, it sounds like pretty soon you're going to need a public relations person with the interest you're getting from across the world. It's a pretty small team for what you're undertaking, and so very exciting to learn more about. I am pleased for the Andes of the UK, and I hope that the Andes in America will have a solution like this moving forward. One of the things we talked about before we started recording was how I ask all of my guests for their predictions about the future of legal education in the coming decade. And so I'm going to ask that of you as well. You are welcome to answer it as it relates to the UK's legal education, or the US, or just as it relates to AI and how it might impact legal education. But I'd love to get your thoughts.
So I think legal education in America and England is very similar, because I've been to a few American universities and sat through some lectures, and it's the law is basically very, very similar. There might be areas that are a bit different, like constitutional law or land law, but contract law is, it's effectively the same for historical reasons. And I still, although I'm getting on a bit, I can still remember my time at university. I went to a university called Durham, which I'm just going to throw a little shout out to for all of you guys listening from America. Durham is I think the only university in the world that has a medieval castle that students can live in. And actually, most of the people that live in it are American students who are sort of in England for a year. And that's because all the English people know that trying to live in a medieval castle in the northeast of England in winter is not an experience you want to have unless you've got 5 layers of clothes on at all time. So you watch American guys and girls turning up in sort of September and they've got a t-shirt, and by about mid-November, you can't see them. They look like they're going across the Antarctic. Anyway, I think what needs to change, and I've been thinking about this quite a bit, is traditionally we have taught lawyers the black letter law, the substantive law, and also some procedural law. In England, the procedural law tends to be more something for law school after university, after a law degree. And I think that is useful. But what I regret as a practicing lawyer, I didn't get a more rounded education. And what I would have really benefited from was, for example, education in human psychology, because when you're acting as a lawyer, you're dealing with humans, and human psychology, and some clients behave really quite strangely, and so do some opponents. And sometimes you can have, and I was a business litigator, sometimes you can have grown business people literally crying on your shoulder in an office. And I'm an awkward British person, so I'd sort of pat them on the back and say, there, in a sort of very British way.
There, chap.
Yeah, there. Step up a lip. Come on, pull yourself together. No, I wouldn't say that. And I feel that would have been an incredibly useful area to be educated in more. And some people joke and go a bit further and say, actually, we should have some education in basic therapy, because sometimes clients seem to want to need that as part of the role. Because you end up sort of providing a counsellor role as well as a lawyer role. And I think we should certainly, in an AI world, move to have more of those softer skills, because I think I'm an AI optimist. I think AI will not replace lawyers, it will enhance lawyers. I think it will enhance legal practice. And so I think anyone who thinks that this is going to get rid of lawyers, I think they're very much mistaken. I think there'll be more lawyers actually at the end of this, because there'll be more disputes, because more things will be economical to pursue. But I think we should think more carefully about those sorts of skills rather than just focus solely upon teaching people what the law is. I was told by an Irish senior counsel, so that's the equivalent of an English SIL, some time ago, about 6 months ago, that about 100 years ago in Ireland, it was considered to be professional negligence not to know the entirety of Irish law. Now, nowadays, of course, that's utterly impossible. But you can see how we focused over time on learning the law, understandably, but less about all of the other sort of factors that goes into being an effective lawyer. And I think we need to think about those. And the other side of things is, of course, teaching about technology. No one can predict the future, but I have been saying for a few years with my tongue firmly in cheek that I felt a bit like a canal owner in the early 19th century who's just seen George Stephenson's rocket go past on the way to the trials near Liverpool and thought, blimey, my entire business is just about to be revolutionized, and I want to be in railroads, not boats on canals. And I think it's going to be very much like that. And there's going to be new skills and new jobs created that we can't even predict that will work in law firms. I think lawyers will probably end up working with data scientists and people like that. And I think it will be helpful for lawyers to be taught more about technology, because certainly in England, the number of lawyers who can do things like program is quite limited. And I like to tell as an example that when I was a trainee solicitor in the 90s, one of my supervisors, one of the partners in the firm I trained at, the computer on his desk was an alien device. His secretary would come in and print out all of his emails and then present them to him on paper, and she would move the mouse around and the cursor around for him on screen, because he had no idea how to do that. And I think there's still elements of that in the profession, and we need to move beyond that. We need to become much more sort of technically fluent.
Yes, I think many of those people are retiring. And, maybe AI is pushing them towards that decision. People certainly are coming up more tech savvy, but the AI is a whole new world, and there's a lot of learning to be done. I'm just curious, before we conclude, are the UK law schools incorporating AI training yet?
I think they are. So the environment in England at the moment is that our government have sort of announced they've got two missions for the present term. One is growth at all costs, and the other one is pro-AI. We're very pro-AI in the UK, as you can tell, and everyone in business has got that message and is keen, and everyone in academia is keen as well. And I think the use of AI and all of the issues that come out of it is something that all the law schools in England have been busily building into their educational system. And I think that's got to be a good thing, because you've got to equip the next generation of lawyers for the future they're going to be dealing with.
Absolutely. Well, congratulations to you, Phillip Young, as co-founder and CEO of Garfield AI, and congratulations also to your technical co-founder, Daniel Long, and the rest of your team. You have started something that we will all be watching, and I appreciate your taking the time to share with us on Aspen Leading Edge exactly what Garfield is doing and hopes to accomplish. It's so admirable and exciting, and I'm really grateful for your time.
Thank you very much, and thank you for inviting me to speak to you today.
Well, best of luck as Garfield AI continues, and I hope you'll stay in touch and keep us posted about how it evolves.
Thank you.